Hello again, and welcome to another of Mosaic's coffee breaks. Mosaic is, of course, a collaboration of the organisations shown at the front of this presentation, and that collaboration focuses very much on the ownership issues associated with mid-market law firms. And when we say ownership, we mean everything associated with ownership, mergers and acquisitions, partnership structures, succession planning, partner exits, and everything associated with all of those issues. I hope you enjoy this broadcast.
Welcome to the latest Mosaic coffee break. Today I'm joined by Howard Hackney and Mark Briegel. We're missing our dash of youthful exuberance this morning, Tom Blandford, but I dare say we'll manage to occupy our time profitably for the next 10 minutes or so. So we don't have a particular theme for this morning's chat, just what's hot and interesting and what are we finding challenging and thought-provoking in the market at the moment. So we'll be going round the table, and I'm going to start, if I may. Good morning to you, Howard.
Good morning, everyone. Morning, Nigel and Mark. Number of things crossing my desk at the moment. One that's been going around for some time is VAT on client deposit interest. It's been going around. It's been having getting certain accountants worked up about whether there's a big issue or not, and I've been looking at it in a little bit more detail. And I think it is an issue, probably not as big an issue as some might be suggesting, but the issue is all around VAT and exempt income. We all should know that client deposit interest is exempt income, whereas fee income isn't exempt and is subject to VAT. And where you have a substantial amount of exempt income, i.e. interest, over certain de minimis levels, you then need to start thinking about doing what's called partial exemption calculations, which basically means you start restricting the amount of VAT that you can recover on your inputs, i.e. your purchases. And I think looking at it, it does seem to be a problem in a number of cases, especially where there is really significant levels of client bank interest. And there are a number of different ways you can do the calculations. And you might be able to get a special method agreed by the HMRC. I was going to say Customs and Excise, by HMRC. So it is something that needs to be looked at to make sure that you don't fall foul of the rules and potentially get caught with penalties at a later stage going down the line.
Well, my first question, Howard, is many of our clients will have had peak client account interest in the period 18 months to 6 months ago, when interest rates were really high and the conveyancing market was buoyant. Do they need to worry about 12 to 18 months ago?
They need to worry about wherever it was in excess of the de minimis levels, and that varies. You need to worry about it, and you can go back 4, 5, 6 years. So the case I'm thinking about, I think they're looking at 3 years, going back 3 years, and it could be significant amounts.
Wow.
I know we've done a number of deals where because client account interest has been very high, that's come into the calculation of the purchase price moving forward, where there's an earn out, it being, we will take a certain amount of that client account interest. So it's certainly an area that people are talking about now that there's bigger sums floating around.
Yeah, because it's obviously recurring if diminishing income, isn't it?
Yeah.
Mark, can we come back to you for our next topic?
Oh, right. I think what am I doing at the moment? I think of interest is I've got a couple of deals on which are non-law firms buying law firms. So the whole sort of ABS thing is back on. One is an accountant buying a law firm with a view that they can then direct their clients towards the law firm and share income, etc. And the other one is, I have to be careful what I say, it's somebody who does sort of non-restricted legal services, buying a law firm so they can then sell their clients a wider range of legal services. So that's quite interesting, gets us into the whole ABS territory and what the SRA want. I've been involved in a number of ABSs over the last few months, and our friends at the SRA seem to, as ever, change their minds as to quite what information they want. The key thing I think I find with the SRA when they're looking at an ABS application is that they want to make sure that the non-lawyers will not influence the legal advice given. And I think, if you bear that in mind in terms of answering any question that the SRA throws at you in your ABS application, that tends to, keep them reasonably comfortable, but they do want a lot of information.
Interesting. Howard, any questions for Mark on that?
No, I don't think so. I'm just interested in terms of what's going on and what's happening in the marketplace.
Yeah.
It continues to change and evolve.
Yeah,
It
so
does.
looking at my to-do list, I've got sort of usual law firm mergers, which are a lot of them still relate to succession planning. And as you know, I've been banging on about succession planning since about 2008, and we've still got partners in their 60s looking at selling their law firms. And a number of partnership disputes. Not quite sure why both law firms and dentists, etc., people are just feeling a bit more grumpy and litigious at the moment. So we're dealing with some messy disputes, most of which, Howard, you'll be pleased to know, come down to valuation.
Wonderful. Always does, doesn't it? It
Well,
always
you
comes
get to
down to
the
the
point,
money.
once they've decided that they really can't work together, it's inevitable that one person's going to leave. So it then just boils down to how much they're going to get to leave and what the payment terms are.
I wonder if either of you saw the piece by one of the directors of the PE company behind the acquisition of FBC Manby Bowdler. He was interviewed for Legal Futures last week or the week before,
Missed that.
and rather boldly said, and I do think it was rather bold, that the market seems to have settled down now, that the valuation of law firms is 5 to 7 times EBITDA. I thought that was rather bold.
Yes.
Yeah. Well, I could think of a lot of firms
Mm,
that go and bite his hand off.
I can think of quite a few firms that'd be very happy with 1 or 2 times.
absolutely. Yeah.
Well, I can think of a
Very.
number of firms who become my successor practice and let me sleep at night.
Yes, absolutely.
Interesting.
On
Yeah.
last week, I spent 4.5 days in London, and I learned a life lesson from that, which is I'm not 45 anymore. And I did pricing training on 4 successive days for a top 50, a top 100, and a top 150 firm. And one of the questions I usually ask in the early stages of pricing training now is, what use are you making on a day-to-day basis of legal tech / AI? And for the first time so far, I got a universal hands up from one cohort. Every
Yeah.
single person in the room was using tech in some way, which is enabling them to turn their services around quicker, but is reducing the number of 6-minute units that are being recorded. And at the
Yeah.
moment, that saving is being passed on to the client almost thoughtlessly. And yet the tech
Yeah.
is hugely expensive at the moment. So, profitability is plummeting from both ends. We've increased expenditure, we're
Yeah.
putting less inputs onto our ledgers. And I think as I've said many times before, I think this is a pivotal year for pricing, because we simply cannot continue to price for inputs when the inputs diminish on a sort of month by month basis. We've got to start pricing what we actually
Yeah,
deliver.
the value add, because
Yeah.
it's knowing the question to ask the AI. The fact that the AI can do it. I mean, on the other side of AI, as you know, I love tech, and we're using bits of AI. But there was also the case a couple of weeks ago that the Haringey Council one, where both the solicitor and the barrister were reported to their respective regulators because their submissions, which had been done through AI, involved cases that had been made up. The AI had made up cases that didn't exist. When challenged, they said, "Oh, yeah, well, they must exist." It appeared they didn't, and the judge was, I think, unamused.
Yes.
Is the
Yeah.
so.
So it's a lesson there for all of us. When using AI, please don't make anything up.
Well, no, it's not us making up; it's the AI.
Well, then
Making.
exactly. Do we have to instruct
Yeah,
Copilot or
Yeah.
ChatGPT, do not make anything up?
does that work? Well, I suppose
Yeah.
if it says, the case of Haddon versus Hackney, we have to actually make sure that case
Actually
exists.
exists.
I have to say, were such a case to come along, Mark, with but both too old and grizzled to settle it in the courts,
Too right.
it would either be pistols at dawn, or if Howard wins the toss, it would be a game of tennis.
Oh, I don't know, not with my tennis skills at the moment. But,
Howard, I
just
think you mentioned another topic you wanted
yeah,
to
just moving
run
on a
through.
little bit. The other topic that applies equally to my two sector focuses, being family businesses and law firms, is the whole area of the changes to pension schemes and the fact that pension schemes will in future be subject to inheritance tax.
Mhm.
And I'm seeing it now with clients. The historical approach has been to put your business premises into a SAS, or for law firms, it's usually a series of SIPs owned by each of the partners. And that's always been an extremely sensible approach, because you get tax-free growth in the pension scheme, you get your tax-free contributions, and you've got the property IHT free away from the company or the partnership. But that's now totally turned itself on its head. And with those properties being, with pension schemes being subject to IHT, I think I'm starting to see people saying, we've got to totally change our strategy now. We've got to start putting our business premises back onto the balance sheet or own them personally rather than in the pension scheme. So I think there's going to be an awful lot of planning and rejigging of pension arrangements over the next year, 18 months. I haven't rejigged any yet, but certainly I've got two where we're saying, forget about putting the property in the pension scheme.
Changing back to personal ownership doesn't affect the ultimate IHT liability, though, does it?
Well, it does. If you own the property, which is used by a company that you control, you can get 50% relief on that property.
Okay, so you get a better relief. Yeah.
But if you don't own, but you don't control the company or
You're
the
not going.
partnership, you don't get it.
So
So
that works if you die in the saddle. I mean,
yes,
interesting. I think I've got an interesting issue at the moment, because you and I, Howard, have discussed over the years, the problem where the premises that the law firm trade out of are owned by former partners, the estates of former partners, and we've actually got a client of mine who you know, because we worked on together, is buying a small law firm, just geographic add-on, nice deal, and it's currently stalled because the former partners who own the premises are holding tough on a new lease for the buyer. And, there's an element of the buyer might actually just either walk away from the deal or just go, oh well, we'll take the business and leave you with the premises.
yeah,
Ridiculous. So
yeah,
there was one we did ages ago with a law firm where there's a side agreement that, I mean, this was all in SIPs, wasn't it? Where when partners join or leave, there's a whole process where the property changes hands in
yes.
similar percentages, which seems to work quite well.
And the normal thing is to have put and call options
Yeah.
between the partnership and the outgoing partner, so they sell if they want to, but they don't have to sell. If neither side wants to exercise the option, they can carry on owning the property. So I think there's going to be a lot of work around that area. Let alone, let me just throw into the mix your succession planning, Mark. EOTs. Again, we've done quite a bit on EOTs between us. There were some changes in the budget last year for the good, to make sure that the value of law firms and any business sold to an EOT has got to be true open market value, and that's very positive. I think we're going to be seeing more and more EOTs.
I had an EOT inquiry last year, which is quite sorry, last week. Good. Is that
interesting? Well, I think that's a useful roundup of what's hot and what's interesting at the moment, and I hope our viewers have found it well worth their time. We look forward to joining you again in the not too distant future, when hopefully young Tom will be back amongst us. Until then, take care, and it's goodbye from all of us.